Yeah, yeah. Welcome all to this session of Gyanavardhini, and I welcome Advocate Atul Khadse to deliver this particular session. First, let me introduce him in some different capacity. He was the person from whom I learned cyber law when I was doing my PG in cyber laws, and that is one say introduction of Advocate Atul. And his professional introduction is he has worked for Nico Steels, Nagpur. Then he worked for FMCG giants Hindustan Unilever for 5 years, and now currently he is Associate General Counsel for L'Oreal, another I can say beauty care products giant, and he is very keen on new subjects, and we will be enlightened by his knowledge, and he has also doing a lot of good things as far as data privacy is concerned, though he is not a member of FDPPI. But after this particular session, I think he will be certainly inclined to uh, become more active on FDPPI forum also. And with this much information, now I hand over this particular session to Advocate Atul. Welcome, sir, and you can commence.
Atul, you have any presentation?
I have. I'll share my screen.
You can share.
Um, just let me know once it is visible.
Yeah, it is okay.
Yeah, it's visible.
Great. So at the outset, thank you, Dr. Mahendra, and it's a pleasure to reconnect to you after a long time. And since you have taken me to my memory lanes, I need to put this on record that right from the day one when Mahendra joined PGTD Law, his sole and whole objective was cyber law. To educate and make people aware on the issues of cyber law. And I'm very happy that now he is convener and holding the session in through FDPPI. So good evening, gentlemen, and it's an honor and to be a part of this particular community, which is focused for educating people on the nuances of cyber law. Now, I have been into cyber law for almost since the inception of the Information Technology Act 2000, when the law kicked in. And that is how since then I'm connected with the law. And throughout my professional journey as an independent practitioner and now as a corporate in-house counsel, data privacy has been always on the top of my list. It's something which we cannot live without. And it's very important for us to understand the nuances of data privacy. More particularly today, I'll be taking you through the lens of corporates, what are the obligations on how corporate view data privacy and why it is important for them. A complete 360-degree shift for corporates, which was not there earlier. But because of the entire go-to market has changed, because of the entire COVID has kicked in, the boundaries are shortened, and it's becoming more and more important for the corporates to be aware and put certain compliance frameworks for and in and around data privacy. So I thank FDPPI for giving me this opportunity to share my minimal knowledge with you. And I'll be more than happy to have this a two-way round discussion. If you have any queries, please then and there you can ask me, or else you can put in chat, and I'll request Dr. Lime to keep a track of it and just ask me those queries. So quickly running through what all we'll be covering today. Definitely we'll be talking as to why privacy matters. One of the biggest concerns that why we are discussing this topic. Law on the data privacy. We know about it, but still good thing to have a refresher around it. What are the data privacy threats and are they real enough? What are the risks corporates run through in and around data privacy? Why it is important for them to have this topic in hand? And obviously the role of in-house counsel, the role of data privacy officer, which has completely changed. With that, the changing market scenario, how it is impacting organizations, different sectors, may it be FMCG, may it be finance, may it be automotive, and the compliance framework around it, compliance framework which is existing, some which I can share from my own knowledge, from my experience, some I can share from the discussions I am having or I have had with the industry leaders on this piece. And obviously the conclusion where we stand and where we need to go on this part. So to start with, why privacy matters? It's because our digital footprints are huge. No, we are connected in this world. And when we are connected through digital medium, data is everywhere. If you have any social media account, may it be Twitter, may it be Facebook, Insta, YouTube, even if you tweet, post or chat in social, there is a digital footprint which is already created. Earlier we used to talk about carbon footprint, now it's more of a digital footprint. You subscribe to e-newspapers, e-magazines, and that is where we are going. Again, your data is already available on the internet medium. Mobile phones, if you are, most of us, in fact, most of us don't know that by default, your mobile locations are on. And even if you go back and Google and just check where exactly you were 3 years ago on this given date, Google will tell you. It's a huge data footprint which we are leaving behind. Whether you watch OTT, you have intelligent personal assistants like Alexa, everything is creating certain kind of data around it. And this data is also capturing your private data. A linkage between who you are and what you do. As far as what you do is something may not be a concern as of now. But from what you do, if you can be linked to who you are, that's a bigger threat. That's a concern. And I don't want my identity to be available everywhere on Internet of Things. And we all are, we cannot live without this because we are so tuned to it. We talk about digitally driven services, may it be Uber, Ola, or food services like Swiggy, Zomato. We talk about shopping world like Mintras of the world, Flipkarts of the world, Amazons of the world. You name service and you will have a tailor-made personal assistance available for it. You have plastic cards. The entire detail of your credit card or debit card is easily available with the banks. And now we are moving away from plastic cards to cryptocurrency. Again, unregulated world at all. And the details are still available. Loyalty programs, we fly, we use launch, and the details are available with them, how many trips we have done, with whom we have traveled. And all this captures data, and that is why privacy matters. Question is my data safe? Everything is digital footprint, everything is in terms of byte. Now, is this data safe? And that is where the concern is. Today, my data is not safe because we are at a very novice stage. There is no dedicated law as such. And we cannot crib about it because we are still in developing mode. There are countries which are developed on this. There are countries which have implemented laws like GDPR, the European Union. Still, they are struggling to implement it in totality. Considering that, we are still at a good level. As I speak to you, almost 166 countries have evolved their data privacy law. May not be directly, but omnibus, like we have Information Technology Act, then we have Security Rules of 2011. Then we have certain elements of IT Act, or for that matter, NACH. So these are certain things wherein some portion of data privacy is captured, but again, not dedicated one. But at least we have something to say that. Out of this 166, you will be surprised that almost 50% have evolved their data privacy laws in last 10 years. And out of that, 50% in last 3 years. So it is catching up. Data privacy concerns are catching up. Countries are taking it on priority. However, there has to be a sync between the countries. Because today, multinational operates not in one territory, but in multiple territory. And when they operate in multiple territory, if there are laws which are conflicting in each other, or there are laws which are creating certain kind of boundaries, it becomes very complex for multinational to operate, and it becomes more complex in order to operate. The bigger concern is data sharing. Ultimately, everything is data driven, more particularly from the corporate world, may it be FMCG, may it be automotive sector or finance banking sector. Data sharing becomes very important. Data is the fuel for organic growth. And unless the data sharing happens, the company won't be able to use the data. And that is where a bigger concern comes into picture when there is no uniformity across the lands. Now, let us understand what is data privacy. Two aspects. One is data, another is privacy. When we're talking about data privacy is basically a right guaranteed by the constitution, which says that, okay, you will be left alone if you don't want to be poked by others. In a way, it's a freedom from interference or intrusion. And data privacy is a right to have some control over how your personal information is being used. Now, when Information Technology Act 2000 came in, obviously, data privacy was not the bigger concern under implementation of information technology. We know that when IT Act 2000 came, it was more to facilitate e-commerce. It talked about the concept of encryption, decryption by way of hash function. For the first time, it acknowledged digital signatures, and that's how the transition, the transactions, global transactions become easier. But over a period of time, the legislature realized that this act alone is not sufficient. The Information Technology Act, which mentioned data as a representation of information, knowledge, fact, concepts, instructions which are fed or processed into computer, it's not sufficient. And to be very precise, the first thing, more particularly governing the cyber laws, or for that matter, the data privacy, it kicked in when the technology rules came into picture in 2011. The definition of data was further clarified, and a new set of definition was created, was sensitive personal data, which included your password, financial information, sexual orientation, biometric record, medical history. And for the first time, government took into consideration that it's not only about the information and knowledge about the person, but the preferences of the person are also included in the sensitive personal data. Now, whether the question is whether this definition is sufficient, again, there's a, we know PDP bill is pending, and there are another set of definitions involved into it. But when we compare this definition with other definitions of the land, somehow we feel that this still not take care. And there is a lot of ambiguity. For example, under French law, discussion around religion is considered as personal data. So you cannot ask a person of which religion he belongs. Whereas if you see Information Technology Rules 2000 level, that is missing. Even if it is, and even that is missing from, I think, PDPP as well. So data privacy, defining data privacy is basic issue. However, we have to work within the ambit provided. And for our purposes, currently, as we see from the corporate lens, the definition is as is provided under the rules of 2011. Now, the PDP bill came in 2018, and sad of state of affair that is still under debate, under discussion. In fact, they have, what I know of is they're going to scrap the entire bill and propose another bill because they want to capture other data than the personal data. But as per the bill, personal data meant all data relating to a natural person, whether individual who can be identified or identifiable directly or indirectly. And in order to cast the obligations, duties onto corporates, onto organizations, they laid down certain rules, data fiduciary, data processor, and entire activity was brought under the ambit of word processing. So if you are storing, using, transferring, entire would be processing, and there were certain obligations. Now, obviously, this data protection bill has been picked up from many other laws of land. Definitely the laissez-faire, constitutional understanding, we have under Article 21. Then GDPR, upholding the dignity of individual. So we adopted right to correct, right to transfer, right to erase, and then certain protections which the China law had in place, wherein the sovereignty of India would overweigh over the individual's right. And that is how collectively a mixture of three brought the data privacy bill. Hoping that this data privacy bill would become a law, corporates actually went ahead and did a lot of impact assessment. Not many, but yes, still a larger number of corporates did impact assessment. Government needs to know that corporates are ready and eager to implement the bill, because end of the day, the obligation lies on organizations, on the multinationals, on the companies, and as they are into holding a lot of data. Now we know what are the penalties. Still, to refresh, the penalties as laid down under the PDPP bill, or for that matter, similarly picked up from the EU GDPR, is around 150 million INR, or 4% of total worldwide, in case if there is any non-compliance of significant obligation by data fiduciary. And in case of other, such as non-reporting of any breach, then it is 2% or 50 million INR. There's a huge penalties under GDPR and other laws. And when we talk of virtual world, when we talk of Internet of Things, when we talk of multinational, these boundaries, they really don't matter. And that is where compliance of other laws also become essential. And we're talking of huge number without having a base. It's very easy for government to pick up an organization and to slap 4% of their overall total worldwide turnover. But is it justified? Unless there is a specific dedicated law and there is a leeway provided to implement, this proposal is not well appreciated. And that is why organizations or multinationals are actually doing impact assessment to understand what are the gaps, and those gaps, how to plug those gaps. Now, data fiduciary is data processor. Every company today requires data processor. Mandatorily, you'll find that where whosoever is into service sector, they have their CAT department. And there are consumers who keep on calling for resolution of their queries. The data is to be collected of the consumer. And that is where these fiduciaries and processor, they are under stress, because the data which is collected has to be properly kept and has to be complied with. But because there is less of regulation around it, less of governing compliance around it, it's still open for breaches. Having said that, definitely an appreciable part that when government has considered such a bigger amount as a fine and penalty, they are weighing data privacy as a bigger subject. Now, from the compliance part, if we compare the PDP bill and as well as the laws which are in existence, what are the basic compliances which an organization, a multinational organization, need to do? So the basic compliances which multinational organization needs to do is first need to do an impact assessment. Any organization need to understand where they stand as of now vis-a-vis the law of land. What are their data touch points? What are those sources from where the data has been collected? It can be anything. It can be your HR department, which collects thousands and thousands of CVs over a period of a year from campus interviews. Or it can be your consumers to whom you are selling the stuff. Once the impact assessment is done, one has to note down where the records are kept. That process is called as data mapping. So once you identify what are the data touch points, you need to do the data mapping. Organizations need to have their own dedicated data privacy officer or a data protection committee, so that any breaches under the topic can be taken up. And if there is any breaches, it can be reported to the grievance redressal authority proposed to be constituted under the PDPP bill. Organization need to put up security safeguards. And while undertaking any project, any program, or while collecting any kind of data, personal data, organizations are required to undertake privacy by design. Currently, as we look into the bill, these are the basic obligations on any of the organization. And most of the organizations have started working on this. While doing an impact assessment, it is important to figure out what are your data subjects. Who are your data subjects? The data subjects can be the consumers, data subject can be your customers, data subjects can be your employees. Who are the data touch points? Now there will be several data touch points. It can be your marketing team, it can be your sales team, it can be your HR. What are the mode of data collection? How are they storing? Where are they storing? Whether it is stored in a encrypted manner or not? Whether the data which is collected is anonymized or not, or pseudonymized or not? Is there any retention policy around it? Now, this is everything which is covered in impact assessment, and this is one of the biggest steps which is required to be taken for corporates. Every project has to essentially run through privacy by design. Privacy by design, or we also term it as privacy impact assessment. It clearly lays down a picture of a particular project being undertaken, whether what kind of personal data is being captured, what are the safeguards which are already available, and what are the safeguards which need to be put in place. So privacy by design empowers the organization to know what are the apparent risk in the proposed project. And if a proper safeguards are put, then definitely the breaches can be avoided. And this is what is the entire compliance for corporate governance is all about. Now, are the threat real? We see a lot of threats around data privacy. And we have been listening a lot that government has banned many Chinese apps in past, in recent time, over privacy issues or concerns. And these are all real news clips which I have taken, may be of banning the apps, or for that matter, China posing cyber security threats. The threat to privacy is real. The problem with privacy breach is that most of the people, when I'm talking of people, I'm talking about organizations. Most of the organizations do not even realize that they have already fallen prey to data breach, privacy data breach, because of lack of corporate governance around it, because of lack of privacy framework. Unless you know what are the measures to be placed, how would you protect that data? And that is why it is very easy for cyber criminals to breach an organization and create havoc in the system. And therefore, safeguarding data, sensitive personal data, becomes very important, very crucial. Now, what is included? Only name and email? Probably not. From a corporate experience, from a corporate angle, name and email alone might not be very important because it's already available in public. But if you are coupling name and email with certain attributes, certain other parameters, may it be behavioral attributes, may it be health information, sexual orientation, images, financial history, then that's a threat. And that's a bigger threat for corporates. And this is where the corporates needs to put in a technology to ensure that there is no intrusion, or at least the risk of intrusion is mitigated. And if the risk of intrusion is mitigated, then the consumers, they will start trusting the brand. I'll give an example. I've been into FMCG for almost a decade. Earlier, I worked for a company which was into more of an FMCG, and now I'm currently working for a cosmetic giant. We know behavioral attributes of our consumers. We know behavioral attributes of our models who comes to our organization. What's their skin tone, what's their hair type, what kind of shampoo they use, what kind of face mask they put. We also understand, probably know what kind of race they come from, so that accordingly we can suggest them the quality of products or the different type of products which are suitable to their skin. At times, the biometric data or images are collected. But then when collectively, if this is taken into consideration and the compliance framework is not put around, there is a huge threat for the organization. Any point of time, this can be misused. And the moment there is one breach which comes into public, the reputation of the corporate is at stake. And therefore, while issues come to us or a business team comes to us seeking our inputs, advice on how to go about with these parameters, we are very cautious. And that is where the corporates need to have their governance policy in and around these parameters. Now, what are the risks? Obviously, the unprecedented risks are first and foremost reputation and trust. It takes ages, decades to build up reputation of a brand, but it hardly takes a minute or less than a minute to de-repute a brand. And any corporate today, whether it is multinational or domestic or national or limited to a state, whether in financial structure or in NBFCs, otherwise, a reputation is at the first priority. You know, and these days it's very easy to allege someone. People have social media in hand. You can just go and tweet something, tag the company, and throw your frustration online, and it will start hurting the reputation. And this is one of the biggest risk for corporates. And that is why the corporates have to have necessarily have a entire compliance framework around data privacy. Once they have a compliance framework around data privacy, and this compliance framework, the nature of the compliance framework is made known to the consumer, the customer, it builds trust. And reputation and trust leads to a good brand. And that is why corporates are ready to have spends around data privacy, to have those compliance frameworks in place. Corporate ethics, another big thing. Any data breach can be an ethics issue. As an employee, disgruntled employee, he has a list of all the suppliers or personal data, sensitive personal data of the suppliers, and you can just post it online or make it available for sale on Amazon. The company's ethics are completely tarnished. There was a study which recently Forbes did, and it was told that as far as India is concerned, the black market rate of PII is the lowest in the country, in the world. You can purchase one PII, which will include your name, mobile number, maybe address, at hardly 0.16 paisa. So that's the lowest, whereas the cost of this kind of data in other countries is high. This shows that how much compliance we are lacking in and around data privacy. As and more the international relations grows, it becomes a risk for corporates. As I said, now with the new data privacy bill which is pending, there is a specific segment of personal data other than personal data and sensitive personal data, which is triggering to health data, and there is a strict embargo of not sharing health data cross-border. Now, all those pharmas which are working in India, majority of them, they are multinationals. Unless you share the analytics of this particular data with the RNI teams, the labs, they won't be able to develop the new medicines. But if there is an embargo, then sharing becomes difficult. And if it is shared in absence of law, then there is a breach. There is a risk to corporate. So there is a lot of risk currently in absence of a governing law for corporates. Now, we know what are the penalties. We discussed what are the risks for the corporates. We also know what is the status of law as we speak. Within the given framework, within the given legal framework, what can be done or how the risk can be mitigated, or probably what steps already the corporates are taking in order to mitigate the risk, in order to put legible corporate governance around data, privacy data, is we will be discussing. And here comes the role of in-house counsels. The role of in-house counsels has completely changed. 10 years ago, a role of in-house counsel for any company or any organization was limited to drafting of contracts, sending of legal notices, doing recovery. And now we see a complete 360-degree shift These tasks, they've been outsourced. No longer the in-house counsel is doing the litigation role. Majority of the in-house counseling are business partnering and doing a non-litigation work. Why? None of the corporates want to go for litigation. But the compliances in and around the law, and not only about data privacy, but in general, are so much that the role of in-house legal counsels have evolved. Legal professionals have evolved. And while we were discussing this topic, Dr. Limier asked me, could you guide audience on how this has actually helped evolve the legal professional? Say tremendously. Legal counsel is no more limited to just issuing notice and doing recovery for organization. Earlier, the role of counsel was only limited to the end of funnel. It was on execution mode. Now, the counsel's role is at the beginning of funnel. Even before the conceptualization of the project, the business partnering requires to take into account what can go wrong and what are the gaps which need to be plugged. The entire go-to-market scenario for organizations have changed. And this is why even the in-house counsel's profession has changed. Now, earlier, there was a simple straitjacket formula. Companies to manufacture or provide services, two of them. And it would be sold in the market to consumers directly or indirectly through the retailers, wholesalers. But we have witnessed ourselves that in past 2-3 years of COVID, how much dependent we have been on Internet of Things. We have shifted completely from the local retail, the local kirana to the online world. May it be Big Basket, may it be Swiggy, may it be Licious, Amazon, Flipkart, Mintras of the world. You name a service and you will have. Even to that matter, you want something to be repaired, you have Urban Clap. From an organization perspective, more particularly from an FMCG angle, data privacy becomes very important because largely we have two sets of data. Now, again, I'm talking about only B2C. I'm not talking about B2E or B2B. One set of data is the retail where the organization is selling the stuff, the goods, the manufactured one. And we have huge number of retailers, wholesalers across the territory. So their financial details are with us, their location details are with us, their names, mobile numbers, and therefore it becomes very important to have this thing secured. Parallelly, there are consumers. So that is how we differentiate between customer and consumer. And parallelly, there are consumers. Now, earlier, the go-to-market was very simple. We used to sell to the customer in turn used to sell to the consumers. But now, both customers and consumers are also coming on e-platform. And we get a lot of data from consumers also, any organization for that matter. Organizations have to necessarily tie up with the e-commerce of the world. They have to run promo throughout the year. And promo will always involve a lot of fancy prizes, buy one, get one free, or for that matter, get a Paytm cashback, for that matter, Big Billion Days, Flipkart days, Myntra sale days. Every time we go on this e-commerce platform, there is a digital footprint created. And this digital footprint is with the customer, is with the manufacturer. And it is where this becomes very important, that with the changing go-to-market scenario, that compliance framework around data privacy is put in place. Because if the compliance framework is not there, the safeguards are not there, a privacy data breach committee is not there, then any breach or one single breach may lead to the risk which we discussed prior. Now, every organization, for that matter, a corporate, works on certain core values. And when I'm saying core values, these are the values which I and you derive as a consumer, I and you derive as a customer, and I or organizations give it in terms of their obligations. Core values are how we collect information. Consumer and the customer in order to build the trust on the brand, in order to build a trust that this particular organization, this particular multinational has a corporate governance in and around privacy, data privacy. It has to be transparent in confirming how we are collecting this information. The moment you reach out to consumer and tell that why we are collecting information, what is the mode in which we are collecting information, that's the first step showing that you are transparent in your affairs. The second core value around the compliance is why we use data. Today, I see there is a gap between what data is required and what data is collected. At times, you and me go to market and you will find that the person over the counter will say that, okay, give me your mobile number, give me your name. They might ask you, give your Aadhaar number as well. Or for that matter, can you also give your PAN number? Can you also write your address? Now, have we asked why this data is required? Every organization needs to have this core value as to why the data is required. There has to be justification if a person's sensitive data has been collected, why a particular data has been collected. Even as a councils, when we ask our business partners, do you really need this data, person sensitive data? Maybe a race of origin, or for that matter, skin tone of a consumer for applying moisturizer. Is it required? If it is the first question, and if the business is able to justify, then we will be able to justify to our consumers and customers that what justifies the need. If not, then need not collect it. So one of the core values is please do not collect just in case data. That okay, आप ये भी दे दो, वो भी दे दो, देख लेंगे. And that is where this compliance framework also works. One more transparency between the consumer and the organization or the multinational is how do we share the information? I'm collecting information for brand X. Now, can I use this information for brand Y? And this happens. Take an example of any company which is a multi-brand company. A company which sells food, a company which also sells clothing. Now, I and you walk in as a consumer, buy certain goods, food products, give our mobile number and name. Now, can this data be shared within the organization with other streams, other verticals? So there is a vertical for apparels, and they can contact you that, okay, sir, you visited our this outlet for purchase of your groceries, and we have to offer you this. So this kind of, now this is at least within that organization. Now what happens if this kind of information sharing is happening within subsidiaries or cross-border subsidiaries? Then there is a question. And as a consumer has every right to know how the information is being stored, retained, reused again. And it is where an obligation on the multinational also to keep the consumer and the customer informed how we use or how we share the information. If we inform the consumer that how we collect data, why we need this data and how we share your data, it is a well-informed consumer, and the consumer basis this information can take a decision whether to share his or her personal data. We need to also tell the consumer that we do not sell the data. We are collecting the data, but we are not using it for commercial purposes outside the environment. It's only the data which is collected for a limited purposes. So the purpose has to be justified. The duration has to be justified by way of a retention policy in place. And the most important is the consumer need to be made aware of their choices. Your choices. You opt in for this service today. If you want to opt out tomorrow, feel free to do so. This is the contact number or this is the email ID, reach us out and you will be out of that mailing list. So giving a consumer choice to opt out for data portability, for data correction, for data eraser is again a core value of corporate governance, of privacy data corporate governance. And with this changing market scenario, when you don't need to go to market and market is coming within your apps, this implementation of these core values become very important. Now, how do we implement these core values? There's a huge compliance framework around data privacy. Now, this is what I'm talking from my experience. It's just not about creating 4 or 5 line items or issuing terms and conditions to the customer or consumer that, okay, guys, listen, this is what our terms and conditions, and now we have collected your data. No, that won't happen. A multinational has to have a complete data privacy strategy in place. It has to lay down what are their policies, what are their procedures, guidelines, documentations, SOPs, who is responsible for by way of DPO duties. There has to be a nominated data privacy officer, then there has to be a nominated data privacy committee. There has to be a RASI matrix that if there is an escalation, how will happen or who will be accountable for what, the organization's accountability, and the organization's readiness for auditing these policies. And if this thing is transparent and made known to consumers, it would bring a robust framework around privacy data. While data collection, as I said, purpose limitation, collection limitation. No just in case data. If the data is required for X purposes, then only the data needs to be collected. That too, if X is justified for that event. Data disposal and data retention. Big concept. Today, there are organizations wherein there is a one-way traffic. We create digital footprint, the data is collected, retained, but there is no transparency vis-a-vis the retention of data, how long the data will be retained. There has to be a timeline. I, as a consumer, when I'm enrolling with company, when I'm enrolling with an organization or sharing my sensitive personal information, I should know that how long the data will be there in the system. And after a given point of time, maybe 2 months, maybe 6 months, maybe 2 years, maybe 5 years, in line to the existing law of land, the data needs to be automatically purged. There has to be a purging certificate. If not, at least pseudonymized or anonymized, so that the identity of the individual cannot be established with that dump of data. And that is where, again, a compliance framework gets in. A very important aspect is consent management, the most important aspect. And we are prey to it. You go to Play Store, you want to download an app, it will ask you 10 permission. Allow your app to take photographs, allow your app to do this, allow your app to do that. And the moment you say no, you cannot further go ahead and further not install the app. Because the consent is not expressed, it is implied. You cannot choose what to consent and what not to. There are very few companies who allow it. One page comes, I agree, and then you move forward. With no option list, we choose that and we go ahead. But is it an appropriate way of doing compliance? No. A compliance framework would be robust when the consent is valid, and not only valid, but also a choice is given to the consumer and the customer to choose what to be consented and what not. And the burden of proof lies on the organization, on the multinationals. And for this, there has to be a consent framework, because consent has to be captured, has to be retained, so that in case there is a requirement to prove the consent was given, the burden of proof lies on the organization. As a matter of choice, the consumer and the customer has the right to withdraw the consent, which is also there in the PDP bill. With this aspect, there are a couple of more things: data processing, characterization, transparency, third party. How would you do the third party data processing? More particularly from the data fiduciary. The first line is data fiduciary with the data processor. Then you have to have the entire life cycle management. Put certain kind of safeguards. How do we de-identify data after the retention period is expired? who will keep a track, because I am in the system. I'm working for this company now. I'm into business. I sell a particular mobile. Today I will collect data. After 2 years, I will leave the company. Who will be responsible for that particular data? How will that person ensure that the data has been de-identified and post retention, the data has been disposed of? Even when the data lies within the system, the access has to be limited, and for that matter, there has to be an encryption to the data. Fine, there may be data collected. I am in the system, but I cannot have access to entire data. My access has to be justified. Otherwise, the data has to be encrypted. And for this, obviously, the contract review, privacy audit, and training and awareness, this happens. So when we talk about corporates and data privacy, it's just not a buzzword. It's a huge chapter within itself. So a lot of to-dos, and this is where the entire shift has happened from the earlier lawyers and that of the corporate lawyers today. To an outside world, the moment I say that, okay, I am a corporate lawyer, probably they would understand, or they would try to connect the dot by saying that, okay, he is handling the litigation part of the company, which is seldom not the case today. There is so much of compliances around privacy, data privacy, that executing this and making it robust itself will take ages. And there's a lot of to do. Now, we saw a lot of compliances. What is available today, what can be implemented, couple of things, and which most of us organizations have already implemented. One of the biggest thing, and I can talk independently on each topic for hours, privacy by design. Privacy by design today is core to any single project which is undertaken by an organization, and may it be any space. May it be in a space of general trade, GT, modern trade, or for that matter, CSD channels. May it be for my customers, may it be for my consumers, may it be for my models, influencers, celebrities with I'm working home. The moment business comes with a proposal that we want to undertake this activity, the first requirement is to run that project through privacy by design. Privacy by design helps to identify the impact. It is called as privacy impact assessment. And it helps the organization to lay down in black and white who is responsible for what kind of information is collected, and it eliminates just in case data. The moment privacy by design confirms that there is a requirement of capturing biometric data, there are 10 other compliances. The moment privacy by design throws that under this project, there will be an audio video recording done, there are another 10 set of compliances. And this is all linked to privacy by design. And this goes to the very root of a robust compliance framework. And the organization which undertakes privacy by design and showcases it to consumer by way of its transparent approach, that brand takes, or it builds the trust of consumer. And that is how both of them grow. So privacy by design is a proactive approach, is a comprehensive approach towards compliance framework, towards corporate compliance framework on data privacy. Now, carry out the privacy by design. Where do you store it? And there is a concept of register, or we call it as data mapping. It's an obligation on an organization, on a multinational, to have the personal sensitive data and the personal data to be mapped properly, so that the accountability can be established, that which department, which function is owner of this particular data, who is having an access, who will ensure the data is purged or anonymized or pseudonymized. And if you have data mapping properly done, it gives a transparency and removes the vagueness of your compliances. And there are various tools available. When I'm talking of privacy by design or register, or for that matter, the consent management, there are many tools available. Like the organization I'm working with, we have implemented OneTrust, which is one of the global solutions for consent and cookie management. So all my consents, which I'm capturing for either my consumers or my customers, whether to offline or online medium, they run through a particular tool, wherein this tool will manage the consents, will date and timestamp it, and will encrypt it and keep it in safe, so that tomorrow, if a user comes and challenges on the consent, or for that matter wants to withdraw a consent, one can directly go to the tool and get it managed. So there are certain tools also available. The good part of the law is that GDPR is already implemented in European Union, and it is being strictly followed. And because of that, it has given rise to many other companies to bring in digital tool and technological advances, which we as multinationals can adopt and implement in India in line to the proposed PDP. And if we have these tools implemented, people trained around it, educated around it, we will have a robust compliance framework around data privacy. Data privacy simplicity doesn't mean to have things in place. No, it means having robust things in place with transparency, whereby the data subject is aware that these are the rights which can be exercised, and this is how the data will be retained with an organization. Just for the sake of audience, as we all are novice in this particular subject, data privacy, we know that this is going on since 2010, probably prior to that, and still we are not there where we should have been. I know Dr. Lime and other team members have been consistently following with governments on getting the appointments done for redressal. They have been law, but the officer is not there, the bench is not checking, the proper infrastructure is not there. But it is equally important to even undertake the awareness in the community. And obviously, FDPPI is doing that. That's the whole intention. And similarly, we are also replicating that at our end, whatever we can do for the community to ensure and make people aware in and around issue of data privacy. Now, this is one of our private examples. I have a team of almost 1,000 people. As an in-house counsel, we wanted to educate them on data privacy, a subject which is but theoretical, list of their concerns until it comes on to them. And therefore, we thought that why not to build a mascot around it? And therefore, we came up with this idea of Mr. Negligent. So what we are doing differently is that we created this mascot, Mr. Negligent, and all our communications are in and around to Mr. Negligent. So that when people constantly see this mascot or they're hammered with the presence of mascot, the concept of data privacy, it gets rooted into the DNA. Something like privacy by design. That if you have to take up a new activity, it has to run through privacy by design. Similarly, every new entrant, every employee, for that matter, should be aware of data privacy. And we have been building our communications, our engagements, education, awareness through a mascot. I will I have that video. Yeah, I'll just play. This is a quick 2 minutes video. I hope the sound will come. If it doesn't, please let me know.
No, sound is not coming.
Um,
Without the sound, we are able to understand, but better sound comes.
Sorry, I could not hear. You guys able to hear the sound?
No, no, no. No sound.
Sound is not coming.
Sound is not coming. I will not replay, but because there is a subtitle, so let us go ahead with that. Or should I give
Sure,
it one
sure.
more try?
No, no, no. We are able to go through the contents.
Sure, thanks.
Yeah, we can go through subtitles.
Excellent video.
So my bad, audio was not there, but so we have created series of events, more particularly series of events which are based upon the business examples, wherein audiences from the different secondary sector, may it be from sales, may it be from marketing, or may it be from consumer advisory department, can relate to Mr. Negligent into their day-to-day working. And this has helped us to inbuild the genes of data privacy within the organization. And trust me, this is something which multinationals have been doing, either through mascot or through constant education and learning in and around. We have been definitely growing on a slower pace as far as the law is concerned. But in terms of education, I think in metros, largely people are gearing up on in and around the issue of data privacy. Having said that, we as the stakeholders have to do a larger work into this area, because this is something which will keep on growing day by day. Today we are talking about data privacy in e-commerce world, in an online world, and we are already working on metaverse, and that's the future. So we're working on cryptocurrency, where cryptocurrency is already kicked in. May it be Bitcoin, may it be Ether, may it be Litecoin, Dogecoin. Cryptocurrency is going to stay, NFTs are going to stay, and this is how the entire metaverse will be captured. You must have gone through the news recently. There was a couple in Karnataka who did their marriage through metaverse. Daler Mehndi brought a land in metaverse. And when we're talking about platforms wherein there will be day-to-day interactions, which will be a replica of your physical interactions, the ambit of personal data or sensitive personal data will be at larger risk. And therefore, not only a compliance framework from an organizational point of view, but a compliance framework from an individual perspective also needs to be placed in. To sum up, I put up 10 golden rules, very simple for any corporate to follow. At least this will help to mitigate the risk in and around data privacy. One, any organization, any multinational, whether it is registered as a company or a partnership firm or a HUF, their data collection process needs to be transparent. How they are doing, why they are doing, is there actual need? This needs to be communicated to the consumer so that the consumer should be made aware and given a choice whether to go ahead, that is opt in, or walk out, that is opt out of that particular process. Second golden rule: individual's consent is must for data collection. The consent, and when I'm saying consent, the consent is not for eternity. The consent is not for a longer period. It is for the subject to event based. If the moment the event comes to end, organizations should be obligated to purge that data. Third, only necessary data, no just in case. नाम भी दे दो, आधार भी दे दो, नहीं. Only what is required needs to be collected. Every individual whose data has been collected, the personal sensitive data has been collected. It may be employee, in-house, it may be external consumer. They need to have the right to amend or delete data. Also, from the corporate angle, sharing of data within the subsidiaries, within the verticals, within the business should be regulated by a policy framework. For example, I may collect data for a particular product, a shampoo. Now, when that particular promo is over, if there is a department which manufactures and sells soap, and if they need that data, if I have to share, probably I can anonymize the data so that the individual cannot be identified, and I can share the data for only for analytics purposes. So there has to be a compliance framework around it, and that's the fifth golden rule. Data sharing with third party has to be absolutely controlled. It may be your data processor who is actually processing data for you, or it may be your co-business partner. At times you will see that there are promos, something like buy a shampoo and get a Gillette. Now, shampoo company will be different, Gillette will be different. But the data which has been captured is being used by both of them. And this kind of third-party data sharing has to be controlled. Again, organizations are under obligation that the cross-border data which they are sharing should be well regulated. Data retention is must for any corporate governance. You need to know what are my data touch points, where I'm collecting the data, for what period the data has been collected, and how long I'm storing. Once that period is over, remove the data from the system. And while it is in your custody, have appropriate mechanism, technological security mechanisms to ensure that the data is encrypted. People are not having random access to the data. Only people who are required to have on a limited know-how basis are having access to the data. That's the 9th point. And last, the organization needs to identify and make people accountable for data protection. Because when it comes to breaches, the organization is the one which will be the face. But unless there is an accountability casted, the compliance framework will not fall. And that is why, in absence of a concrete law laying down obligations on corporates, it is important for organizations to have their own self-regulations through something like 10 points of golden rules, or the core values, or the ethics, which will regulate their compliance framework around data privacy. The topic is vast. We face day-to-day challenges. People come to us that, okay, we want to do the medical consultation online. We will be capturing video. What are the compliances we need to do? Or for that matter, somebody will come and say that, okay, I need to run this promo. I'll select 50 first winner. Out of that 50 winners, 1 will be sent to Paris, 2 will be getting iPhone. Again, lot of data, third parties involved. How do you and what are the checks and balances you're doing? So there's a lot of work which organizations are required to do. And that is where it is important that a complete governance framework is available in and around data privacy. I think the topic is such that we can talk for longer time, but I hope this would have given you a visibility of how corporates are also geared up on data privacy and what are the angles they are checking while implementing the personal data privacy within the organization. And that's a very gray area, that's a new area, and an area wherein legal professionals can contribute a lot. So thank you, team FDPPI, for giving this opportunity to be amongst you and sharing my experiences and thoughts over the topic with you. If there are any questions, I'll be more than happy to take it.
Yeah,
I have a
before any
question.
question comes, 1 minute. Before any questions comes, first let me thank Advocate Atul for this nice insight and corporates views regarding data privacy. And now floor is open for Q&A session. Yes.
Yeah,
Yes, I have a question.
1 minute. Advocate, first of all, thank you very much for the nice and excellent presentation. Two things I really wanted to, which I liked in your discussion. One, the compliance framework for the privacy data governance, what you talked about, starting from data privacy strategy to collection to retention. Oh, really? I think this is what interesting for the organizations, irrespective of the size and complexity, need to really look into, right? And till you talked about training and awareness, really a good thought. And second, what you talked about, that the legal counsel getting into the beginning of the funnel, not at the end. Quite interesting. Be with us. This is exactly what we are trying to do at FDPPI as part of our data protection standards of India, wherein we bring in the top management, including the legal director, etc., at the beginning of the business itself. Not only when we talk about privacy by design or default, right? Beginning of the contract, beginning of the occurring of the business itself, we are talking about it. I think really I liked these two. The last one, when you said that you talked about 0.0016 paise per PI in India, and you said that you are trying to relate it to the compliance aware, issue in India. But I look at this way, that awareness issue of the PII in India at this point of time, that thought. But believe me, thank you very much. Quite a nice session, Advocate. Thank you very much. Yeah.
Thank you for highlighting those key things. And this is a topic which actually doesn't require us to do the execution part of it. Each one of us, if they contribute at the beginning of funnel, obviously things get more resolved.
Yeah.
Thank you.
Great. Because I really excited in the sense that if you get an opportunity, I would request you to go through the data protection standards of India, what that come out as part of FDPPA, and it's a brainchild of Navi. We started talking about it, and we have in fact seen the implementation of few of the smaller organizations of this framework, and this is exactly we talk about that. So there is a kind of direct mapping. I really liked it. Thank you very much, really. Thanks. Yeah.
Thank you.
Advocate Khadse, this is Deepak here. I have a question.
Yes, Mr.
Can you throw some light on harm analysis with some practical examples on how you've done it in your organization?
Sorry, if you could come back again. I missed on one word.
Harm analysis. So any examples on harm analysis, how you've gone about doing it, or advising your customers or corporates on how to go about it?
So okay, I'm probably getting your question. When you say harm analysis, you want to say impact assessment in a way, or probably a breach remediation.
No. So there is a particular section in the draft PDPA, or even in the GDPR concept, it talks about harm analysis. That means whenever an information is collected, the organization needs to do an harm analysis from a perspective of the individual and not from an organization perspective. So like information security looks at risk assessment, which is the harm to the organization itself, whereas this will have a focus on the individual's information, whose information we collect.
Right. So answer to this is basically what we do is this both of not only on the security aspect but on the individual aspect is something which is inbuilt for us in our privacy by design. So we have developed a tool which actually takes into account both the independent individual aspects of the information which is being collected as well as the technological aspect. So whenever we kind of initiate any project, no, and more particularly when it related to capturing of personal data of maybe influencers or celebrities or even models or consumers, we undertake analysis in terms of how it will impact, if it is belonging to a particular race, particular sector, state. In that case, what would be the impact of it? Maybe on the skin tone, because I belong to a cosmetic industry as of now. And when we belong to a cosmetic industry, it's all about skin tone and color, or the tone of your, the texture of your hair from shampoo and conditioner perspective. So when we collect this kind of sensitive information, and at times consumers also share medical information, we undertake an analysis in terms of whether this is required, not required, what impact it will have on the further studies, and we restrict it.
No, so would you consider, like, for example, and I'm just taking a random example,
Please.
that suppose if there is, say, a ransomware attack, and this data is now leaked to whoever's caused this, then would you consider that, if somebody has a, skin analysis or tone analysis of an individual, what could result in a harm to that person?
Yeah. Right. Now I'm coming to your questions. I get it. So we do undertake this kind of basically we call it as a mock trial, mock trials for us. And what we do is, because we have been through certain breaches, not a reportable breaches, but within our own environment, something which was not on the intranet, something which is not on the IoT, but within our own environment, and we could realize that there was free access available and there could have been worst impact. And therefore we have a dedicated constituted data privacy committee in place, and we have a target of conducting at least 3 surprise mock drills whereby we take up projects which are already available or which are in pipeline, and we do an analysis. If this is happening, if this happens, then what would be the impact and what would be the risk mitigation factors of it. And that is where there is a RACI which is built up, which actually lays down the process of how to arrest that and what would be the impact of it. So we do undertake this kind of activities because for us, these kind of sensitive information are really crucial. And we probably, at the time of doing the privacy by design, we also undertake this concept called as what can go wrong, and we tick mark it that, okay, these 5 things can go wrong. So while the data has been collected, probably to give you again an example, if you are able to relate, when collecting hair textures, from a video consultation or to a photo consultation, the hair texture is collected, the photographs are collected from the consumers or the models in order to tell them which product is more suitable, given the topography, given the texture of hairs. Now, the moment the images are captured, the very first thing, because of this analysis which is already done, as you say, harm analysis, we would anonymize the data which is collected. So what essentially we would do is we would probably remove the eyes, nose part from the image, so that even if the data is resting and tomorrow there is a breach of that data, the data becomes redundant because the individual identity cannot be established. And data which has been captured can be used only for limited purpose of analytical study. But again, as I said, we are still evolving on the subject. As compared to other organizations, there are certain steps which we have taken, and it's a learning process on the platform.
Okay, I got it.
Okay, any other questions?
If there are no any other questions, I think we can once again thank Advocate Atul and conclude the session. Thanks all for watching this particular session. And thank you, Mr. Atul, for this wonderful session. Hope to see you again on some different topics. Thank you. Thanks all.
Thank you. Thank you for
Thank you.
having me here. Thank you all.